If you're undocumented, how can you get a green card? Well, the 601 waiver process is one way, one legal way the United States allows undocumented personnel to get green cards. Let me explain. If you entered the United States illegally, or let's say you entered the United States and your visa expired and you are trying to get a green card, there's consequences. United States government aren't just going to willy-nilly give you a green card just because you married somebody. Here's what you have to do. In this case, the female entered the United States illegally. The husband is a green card holder and not a U.S. citizen. So if the husband was a U.S. citizen and if the wife was able to get DACA or get advanced parole and leave and come back, then they could get a green card. But many people can't get DACA. Many people overstay their status, and not everyone marries a U.S. citizen. And there are lots of reasons why maybe their spouse can't become a citizen. Every family has their own perspectives as to why you should go from green card to citizenship. In my opinion, there's so many good reasons to go from a green card to a citizenship, and especially in this day and age, I feel like the rights and privileges of green card holders are like gradually, not even gradually, are being stripped away at an aggressive rate. So you should try to become a citizen as soon as possible. But I understand some people cannot. In that case, what do you do? So again, today's story, the mother of 3 U.S. citizen children and her husband, who is a green card holder, how can she get a green card? Well, in July of 2022, we filed the 601 waiver, 601A specifically. Before 2022, we filed the I-130, everything got approved, and now we have to do the 601A waiver. What is a 601A waiver, you ask? It is proving that without her here, it will cause extreme hardship on the lawful permanent green card holder's life. It will cause extreme hardship on this lawful permanent resident. And so, the argument goes, if the United States government deports her, you are essentially slapping and causing hardship on your own citizen, on your own lawful permanent resident. So to protect them, to empower them, you forgive this undocumented person's immigration crime, and in turn you give them a green card. That is essentially the legal theory and the legal pathway in which an undocumented person becomes not just documented, but get a green card. But you have to prove extreme hardship, not just any hardship. And they go on and explain, just because 2 people are separated, it is not extreme hardship. There are plenty of people who do long distance dating. They have long distance relationships. And just because, a spouse is separated from you, that doesn't necessarily mean it's extreme hardship. It might be hard, it might be a hardship, it might not be pleasant, it might be inconvenient, it might be costly, but you have to rise it to a point of extreme hardship. So, how do you prove extreme hardship? In 2022, we filed this case. The client was born in the 1980s. They're approximately 30 years old. They've been married and they have 3 U.S. citizen children. And you might say, you have 3 children together already. That proves that the marriage is real. That proves that without her, the U.S. citizen will have to take care of 3 children alone, and that is extremely hard. But you are actually misguided because, again, we got a request for evidence, and we see a lot of this as well. The burden of proof and the standard of proof and the argument is not that the marriage is real or not. Right? You're thinking you marry a U.S. citizen, it's a normal family petition, you're thinking I-130. Those bases, if you get married to a U.S. citizen and your marriage is real, then you get a green card. But we're talking about forgiving somebody who's been illegally here, who crossed the border illegally. That's an immigration crime. And you need to prove way more that your relationship is real. You need to prove that there will be extreme hardship on this lawful permanent resident. And here's the things that USCIS will challenge you on. Prove to me why this lawful permanent resident cannot just go with her back to her home country, right? If it's so hard to be separated, then go, leave together. Many US citizens and many lawful permanent residents thrive overseas. There's expats all over the world, treat it as a vacation. I mean, they don't use those words, but you have to prove why you need to be here and she needs to leave, and that will be hardship. Would it be good, right? Or maybe this undocumented personnel is actually harmful to the lawful permanent resident. What if the lawful permanent resident can thrive and marry better, for crying out loud? It is a hard reality to face, and it's a hard argument that you have to muster together. And that's why it was so hard to file this case in the beginning, because, again, the mentality of these people who have been here illegally for so long, they are in trauma. They've been undocumented. They've been living in the shadows. Why would they take everything and submit to the government and say, hi, I'm here, please approve my green card? It is an extremely scary application. You're pouring yourself out there. And again, 3 young children. If mother gets deported, the consequences on the 3 kids, the consequences on the father, unfathomable. And the repercussions of that extend to the whole community and to the extended relatives as well. It is a very hard decision to do, to file these type of cases, especially if you feel like your case isn't even that strong. So when we filed this case, it was slow to get documents, but we did our best to make the argument that without her, there will be extreme hardship. Here's a small legal criteria that maybe not a lot of people know. You cannot argue that without her, there will be extreme hardship on the children. The law doesn't allow for that. You need to do an indirect argument to say without her, there will be extreme hardship on the parent, because now he is a single father taking care of 3 kids. It has to be on that individual. It doesn't provide a legal pathway to say without you, the US citizen will suffer. Again, most people don't know this, but you can do a 2-part argument. You could, let's say, assuming the kids were older, not this case because the 3 kids were all very young, right? Teenagers and even younger. But if the children become 21, the children can petition the mother to get the I-130 approved, and then you still have to make the extreme hardship argument on the spouse. Okay, so most people don't know that, but that's a way in which undocumented people can get their legal status. But again, you are proving to the government, without her, this family unit would crumble, and if this family unit crumbles, our entire country is built on the foundation of families, right? If families crumble, companies crumble, then the government crumbles as well. So we want to build up the family. It is so important. And so we make the argument that without the mother, the husband, being a single father, have to take care of 3 kids, and it will be extremely, extremely difficult. Okay, so let's go through the initial filing, all right? I'm just gonna go over top down some big arguments, okay? And then we'll get into the request for evidence, which is usually a lot more interesting for most people. So we argued the emotional and marital hardship, we argued the medical hardship, we argued the financial hardship, and we argued that if they leave, the Mexico crime activity and economic severity presents a real threat to the lawful permanent resident. And then we also proved that she has a good moral character. So those are all the things that we had to prove. The total page count was about 35 pages of attorney brief, and the exhibits, let's see how many exhibits. We have 55 exhibits. I will go through the exhibits, okay? So people could see what we did. So the first 4 is just who they are, biometric information. Now the marital emotional hardship, affidavit, so they're both letters personally. The birth certificate of the US citizen, children, so that's 5. Birth certificate, more birth certificates, right? Photography, photographs of their family, and then articles about single fathers raising kids. So that is the marital hardship. the key documents we submitted. Now, the medical hardship, we included a lot of medical hardships on the children and the article's effects of bullying on the U.S. Citizen children and the deficiency of anemia. So a lot of medical hardships on the children, but the husband is quite healthy and well, right? Ideally, we would have, of course, if the husband was suffering from cancer or something, but this was a strong family, and the children had various conditions now that the father had to take care on their own. Financial hardship. We included tax returns, we included a budget, we included employment verification letters, and then we included all the economic info from the World CIA Fact Book page to show if the entire family were to relocate to Mexico, their living standards and their prospects of their life would just completely drop, right? They are making money and living in the United States. If they were to leave, these U.S. citizens, their future completely decimated, as well as the lawful permanent resident. So then we go on to Mexico's crime rate, specifically where they lived. So we pulled a bunch of FBI facts on that. And then the good moral character, again, more affidavits, and as well as the FBI reports, and a lot of letter recommendation from everybody else. So total 55 documents that took probably over a year to collect, and a 30-page story to prove that without her, the lawful permanent resident husband was suffering extreme hardship. It was a compelling argument, and then after almost 3 years of processing, and right now, by the way, the processing time is almost 4 years, we get a request for evidence. The United States government says, sorry, that was great, but that is not enough. I want to see more. So I'm going to read you some of the key things in the request for evidence. Deficiencies in extreme hardship in bold underline. USCIS has determined that your request for a provisional unlawful presence waiver does not include sufficient evidence that your qualifying relatives would experience extreme hardship if you were denied admission to the United States and therefore be unable to immigrate to the United States. Separation. Regarding the scenario of separation, your qualifying relative remains in the United States while you remain abroad. You claim your qualifying relative will experience the following extreme hardships if you are unable to reside in the United States with them: financial consideration, personal considerations, and then on the bottom, in all bold, no extreme hardship determined, underline. USCIS considered each of the hardship claims related to separation and or relocation individually and collectively. Based on the evidence you provided, USCIS is unable to determine that the overall hardship to your qualifying relative due to the cumulative effect of these hardships would rise to the level of extreme if he or she were to separate from you and remain in the United States while you reside abroad. To be eligible for a provisional unlawful presence waiver, you must submit additional evidence to establish that your qualifying relative would experience extreme hardship based on the designated scenario of either separation or relocation. Or alternatively, you may submit additional evidence establishing that your qualifying relative will extreme hardship under both scenarios of separation and relocation. We always provide both. We just make those arguments. It is not necessary, but we do it anyways. Because why not? Okay? If you're given a test, if you can have 1 hour to do it, or you can have 5 hours to do it, what would you do? Spend the 5 hours to ace that freaking test, right? So U.S. immigration law is funny in that sense. H-1B, a lot of things, they always provide alternatives. You can argue this, or you can argue this. This is a factor test. Here's 8 factors. As long as you prove one of them, then it'll be sufficient. Well, then prove all 8, right? It's crazy that people don't, but people don't. So we provided both, and we argued both. And what's annoying about this USCIS RFE that I didn't like, and you can't have everything, right? They didn't really go in depth and challenge what we already submitted. It was a very much boilerplate request for evidence that just said we want more, but they didn't say why what we provided was not enough. So, given the situation, the family suffered extreme hardship based on the request for evidence. And that's an argument that I haven't quite used yet, but I would love to one day. And said, you know what? The family didn't suffer extreme hardship until you gave this request for evidence. Now they suffered extreme hardship, right? Because they gave everything, they poured their heart out, they put themselves out in the open, and now you're saying that they're going to be deported. Well, now that is extreme hardship, right? They suffered mental anxiety, they started seeing therapists, and we actually did have them go see a therapist. And the therapist actually uncovered something that was quite powerful. We try to dig information out of clients as much as we can. We work really hard being a good listener, thinking and just receiving information where and then we take what we were given and we try to make it the best possible story. But as hard as we try to do that, there's some things that the clients still don't tell us until they go see therapy. And in therapy, we discovered that the husband's father passed away. And if it wasn't for the spouse helping the husband recover from that trauma, they would not have survived. Here is an analogy that we use very often. We want to prove that the qualifying relative, in this case, the husband who is a lawful permanent resident, we want to prove that they are a very broken individual. They're on the brink of completely collapsing. If you take an egg as an analogy, it's a cracked egg. It is about to just break open. It is weak, it is fragile, and if it wasn't for this undocumented illegal alien who's propping up this broken individual, that they will collapse and the United States will suffer. In this case, we demonstrated that the father passing away caused such emotional turmoil for the lawful permanent resident, having to go through that kind of suffering. And then, if they were to lose their one and only support, the spouse, it would be game over for that individual. And then if the only caregiver to the 3 U.S. citizen children is also gone, right? The wife is gone, the husband is gone, then the 3 children left to fend for themselves would also suffer. We were able to build upon that and make that argument. The next thing that we also uncovered was the amount of work that the mother did to care for the 3 kids. The 3 kids, some of them suffered in school. The mother looked into it and found another school that was more appropriate and transferred the kid. A lot of home care, a lot of child rearing is left with the mother. The father has to work and provide, but the mother cares for the upbringing and the establishment of the family and the home. She did all of these things, and we documented it well. I know a lot of people, when they do these type of cases, they say the good moral character section, simple. You just get an FBI report and say there's no crime and activity, therefore this person is a good moral character, but for the fact that they entered illegally and they stayed here for that long. That might have been sufficient years and years and years ago, but we want to go way above that, right? Because being a good person does not just mean having no criminal records. It does not mean just being completely void of a criminal record. There are plenty of very evil men and women who've committed serious crimes, but because they're super wealthy, they bribe their way out and they have no criminal records. Does that mean they are a good person? We obviously understand no. So what can you prove that they are beyond an ordinary individual? The care that this woman provided to her family and the community and all the letter recs that people were able to write for her, we essentially prove that most marriages break apart and get divorced within a relatively few years. Most people cannot raise 1 child well, but this woman, even though she's undocumented, raised 3 outstanding U.S. citizens and gave the care needed to make them thrive and help their husband overcome severe trauma and made this little family thrive. The United States should be grateful for her services and grant her the long-awaited green card that she desperately ask for and please for. It is discretionary, but we are submitting to the USCIS officer. Would you be kind enough to approve this case? We close it, and let's see. It was a 12-page attorney brief, and we provided 40 additional new exhibits. So in total, almost 90 exhibits from the first filing to the second filing. Submitted it, and let's see, when did we submit it? We submitted it in January of 2025. Oh, no, January of 2025, we got the request for evidence. We submitted it within 3 months because they had to go through all the psychological reports, and we rebuilt the whole thing. And we submitted it, I think, in April. Let me see. We submitted it. Oh, no. We got it in January, and we submitted it in February, and we got it approved in April. The family is overjoyed. We are very thankful. And hopefully this story inspires hope and trust that the United States Immigration Services, USCIS officers are good, are understanding, and if you believe in the system, as crazy as it is right now, that this legal pathway of proving that you're a good person, that without you, a U.S. citizen will suffer extreme hardship, it could still lead to a green card. If you have any questions regarding this case, regarding anything, feel free to reach out. Hopefully we could be of help. Take care. Bye-bye. All right, so that was the success story for the 601 waiver. Again, Margaret and Gabby's team did an amazing job building this together. It's a long process, right? Over 4 years, but we're there every step of the way because that's what our promise is. Now, I'm ready for additional questions before we close out the live session.
My spouse has panic attacks when I'm not around. We have a therapist letter. Will that help the waiver?
It will for sure help the waiver if you can prove that your spouse, who is a qualifying relative, desperately needs you. Without you, they have panic attacks. So there's therapists that show the person always needs you. But you want to go in depth and explain why, and you want to explain what are the things that you do in addition to provide that additional support and provide that story, right? How long have you guys dated? How long have you guys fell in love and all this stuff? Because again, you want to demonstrate that you are the only person that they can rely on.
I am in Mexico and my U.S. citizen husband had a breakdown after I left. Can we apply for a waiver from here?
Yes, you can apply for a waiver overseas. It won't be the 601A, it'll be the 601, but it's a similar idea. Your U.S. citizen husband desperately needs you. And so because you cannot come back, because you're overseas, he's breaking down. His entire body, his mind, his soul, his spirit, everything is breaking down. You could document his travels overseas. It is extremely costly. He's going in debt, but he needs to do this in order to survive, right? And so he could demonstrate the money that he's sending abroad to you to care for you. Now, if you were able to get the green card and come back, he wouldn't have to send money overseas. It will benefit the U.S. economy. You want to demonstrate all factors of your relationship and its impact on the United States, him, his employer, your future in the United States, and yeah, so much more, right? So it's much more than just a lovey-dovey feeling thing. You want to include a lot of these exhibits and arguments and storytelling.
My U.S. citizen spouse takes care of our autistic child alone. Because I'm stuck abroad, can we apply for a waiver?
Your U.S. citizen spouse is taking care of your autistic child alone in the United States. You are stuck abroad, and can you apply for a waiver? So the answer is yes, right? This extreme hardship waiver is built and made for people who are suffering like this, right? Without you, the U.S. citizen has to do so much more. So can the government waive your immigration wrongdoing and provide you a relief so you can get a green card, so you can come to the U.S. So prove, again, your worth to your U.S. citizen spouse, to the child, and to the overall U.S. economy.
Where are you located, please?
We are in the great city of Artesia, California, right next to Anaheim, where Mickey Mouse lives.
Is it risky to file an a N600 now? Do they usually get accepted, and is it better to have a lawyer do it?
If you have a good lawyer, it's probably better having no lawyer. Having a bad lawyer is probably worse than having no lawyer. N600 is relatively cut and dry, so as long as you do an application correctly, provide the documents, you should be able to do it on your own. My recommendation is look through the N600 requirements, prepare the documents, and if you feel like you have some questions, you want somebody to double check, then hire somebody who does a lot of N600s, review it, and to give you some feedback. And then maybe you can just do it on your own, but at least you have somebody double check and review it, right? Lawyers, what we do, we just do this day in and day out. We make all sorts of arguments and we put things together. And so that's our expertise. That's what our team does. Gabby does a lot of the N600. So if you have any questions, feel free to reach out. Jump on a call with Gabby. Maybe a 250 consultation would solve all your problems and you will be able to get it, right? We try to do these type of consultations to help as many people as possible. We don't have to do every single case. It is not a sales call. We are not trying to get more cases. We just want to help people. We came into this profession trying to help as many people as we can possibly can, and the 250 consultation is one of the best ways we could do that.
Can a single mother with cancer apply for a medical stay of deportation while on OSA?
We don't do a lot of these humanitarian court cases, so I'm sorry I wouldn't be able to answer that for you. It sounds extremely sympathetic. I believe a good lawyer who does a lot of these deportation removal cases might be able to help you, but that's just my gut feeling from what you told me, you know. But again, we don't do the immigration court deportation stuff.
Hello, sir. Can I renew LPR with a DWI misdemeanor non-aggravated happened 8 years ago?
Can you apply for a green card renewal even though you have a DUI that was about 8 years ago? Just try and see what happens, because based on everything that I know, when you file an I-90 to renew your green card, typically it is a very straightforward process. There is not a lot of scrutiny to renew green cards. However, if you have a criminal record that the government is sensitive about, then they might challenge. And they might give you a request for evidence, then they might challenge. And even if the government doesn't do that, if you leave the country when you come back in, the customs officer who sees that come up, they might challenge you, right? And so it is best to apply because the chance of getting approved is much higher and greater than it not being approved. And then if you do get challenged, you can have the opportunity to explain and prove it to still secure your green card. And it is definitely much better having a new 10-year green card than having an expired green card. So based on what you told me, I would recommend you applying.
Can I use my EAD to fly within the US?
4 or 5 months ago, almost all the immigration lawyers around the world will tell you, yes, it is safe to fly within the United States with an EAD card, because there's no custom officer when you get off the plane. When you get on the plane, you're not going through customs. That is not how our immigration system works. Our immigration system works when international flights are coming in. However, we have seen USCIS, CBP, ICE agents around airports as well. We haven't heard major news of crackdowns because I think that will be crazy. 4 or 5 months ago, almost everybody will say there's no risk, but now maybe there's some, but we're talking maybe 1%, you know?
My 601 was denied last year. We now have more medical evidence for my spouse. Can I reapply?
If your 601 has been denied, can you reapply? And you have more documents to prove it. Yes, absolutely. You can apply again and again and again. So don't give up hope. Keep on preparing and argue it better each time.
My wife lost her job when I left. She's struggling with bills and our U.S. citizen kids. Is this enough for a waiver?
It is really hard to say what is sufficient for a waiver, right? What is enough for a waiver? I don't think you want to think in terms of what is enough and then I'll do it. I think the better perspective is how can I prepare my story so it is the most compelling story that I can prepare? I don't know if it's sufficient enough. I don't know if it's passing, but I'll do my best to do a compelling story based on the things that I have and then submit it to the officer. Your goal is to make the officer who reads your application have a single tear fall down their cheek, to go home to tell their spouse, look who I proved today. This person really deserves a green card. If you feel like your story doesn't elicit that kind of emotion, that heartbreak, then you need to work a little harder, right? So don't think about it if sufficient or not, because there's nobody who could tell you that, right? Even this case, 3 U.S. citizen children, still a really scary request for evidence. So at least that's a mentality that we have at our firm, right? Because there's who are we to say what's enough, what's enough? Different administration could change. This is 4 years from now. What's going to happen 4 years from now? What kind of immigration policies will be set at that time? So my suggestion is just to do your best and then have faith that it will be sufficient.
I overstayed my visa, but now my spouse is in grad school and I support us financially. Does that count as hardship?
It counts almost as hardship for you because you are helping your spouse go through grad school, but it is not hardship on them. They gotta, you know, they're getting it good, right? They're going to grad school. They're improving their education. What's their suffering? So how do you convert that to an extreme hardship argument? You want to combine and commingle your finances, which I'm sure it is, but you want to make that argument. As a family unit, this is our career and a life goal. We are significantly going into debt. Grad school is extremely expensive, but the future is promising and it's bright. You are working hard to make ends meet, to make it work, but together you guys will have this in the future. But without you, they will go in debt, they will not graduate, everything will fail, life will be miserable. So that's sort of the argument you want to kind of spin it. But again, you never know exactly what is sufficient, what is enough. You just have to do your best to kind of make those arguments into your application.
I was denied entry at the airport for suspected immigrant intent. Can I fix this with a 601 waiver?
You have been denied at the airport because you've been suspected for you have immigrant intent. So your visas are canceled. Can you fix this with a 601 waiver? Yes, but that is a little extreme. You might be able to fix it with just an H-1B visa, right, or an L-1 visa, because those two visas allow for immigrant intent. So if you're able to get a visa that allows for immigrant intent, then you can come back into the country and work. And then, if you really do have immigrant intent, then you can adjust status and get a green card. So you don't have to go as far as doing a full-on 601 waiver. And also, if you have been denied for having immigrant intent, if you don't have a bar on your, if it's just a simple denial where you're not allowed entry, you cancel your visa, you left, you could do a petition, a spousal petition, and just get a green card within maybe 1 or 2 years. Overseas. Yeah.
Will criminal records automatically disqualify me?
Will criminal records automatically disqualify you from applying for a 601 waiver or from an immigrant petition? That depends on the type of criminal activity and what you can do about the criminal activity and how strong your waiver case is. There are some crimes that you cannot waive whatsoever. Today's 601A waiver case is just trying to waive the unlawful presence. But let's say you have theft. Let's say you have reckless driving. Let's say you have a DUI. Let's say you have other compounding immigration violations on top of unlawful presence. Then you have to apply for the 601 waiver, which you still make the same extreme hardship waiver, but now you need additional proof to prove that you are a good person and that the extreme hardship that you would cause if you were deported on your spouse would be significant, right? So you just want to increase the arguments and the document to prove it. But the answer to your question, just because I have criminal record, does that bar me? The answer is no. Plenty of people who have criminal records have still gone through the 601 process and gotten green cards.
Should I be concerned about my I-160A waiver being denied with no record as a DACA recipient?
As a DACA recipient, you file the 601 and you are concerned that the case will be denied because you don't have a good argument, or what's that question?
Should I be concerned about my I-160A waiver being denied with no record as a DACA recipient?
I'm assuming the question is if your 601A is denied, will they go after you, right? You are a DACA recipient, will they go after you? Probably not, because you're a DACA recipient.
Last question. Do you have any tips of the letters that need to be written for the waiver?
Yes. Okay. What should the letters include? How many should it include? Quality is definitely more important than quantity, right? You can have like 20 letters, but if they're all really lame, it's probably not going to help that much. The officer, reading through the 1,000-page that you submit, right? Most of our cases are 1,000 pages, right? We exhibit 100 exhibits, right? If each exhibit is 10 pages, that's 1,000 pages, right? So they only have about 20 minutes. And a good 10 minutes of that is going through your form. So with the rest, how are they going to read if you submitted 20, 30 affidavits, right? But here's another thing. You never know what they're going to spend that 10-minute reading, right? So it could be the attorney brief. They could skim through that. They could skim through the checklist. Or they could just directly go to, hey, this is what the son wrote. And they're going to take a look at it. And if it looks like it's written by ChatGPT, and if it just looks like a bunch of fluff, not that important. So for example, if you have a 5-year-old kid, if you have a 3-year-old kid, if you have an 8-year-old kid, their writing is probably not that sophisticated. Their drawings might be more important. I don't know how many cases we've won because we told the kids, hey, you know, while mommy and daddy and the lawyer were talking, here's 5 blank sheets of paper. Can you draw your family? What does your family do on last Sunday? What makes you really happy? And they draw it out. And we submit that, Exhibit 1. What would elicit tears from the officer? Now, in these letters, talk about stories, talk about real things that happen, and don't do conclusory sentences like, without her, without him, I would suffer extreme hardship. That's the point, but prove it to me, right? Whisper it as opposed to directly stating it, right? So stories, how you know this person, the good character, things that only you would know. That's what's most important. And get letter recs from individuals that have good standing in the community, pastors, nurses, teachers, right? Other professionals who are caring for society as a whole, and they vouch for you. If you could show, you demonstrate help to them, that is really powerful. Thank you guys for all watching. I really enjoy doing these live sessions. I really, really appreciate all the questions. And we try to do this every Thursday, God willing. And so thank you, and I'll see you next week.